All right, so let's jump into 5.4, which is the judicial branch. So this is going to be split between this ed puzzle, and then we're going to finish it up at the start of class next week on Monday/Tuesday. And then we will be done with AP Gov. So this is the last slideshow of AP Gov. Congratulations, you made it. Super exciting for all of you. So let's go ahead. When we're talking about the judicial branch, right, we have to first start with the U.S. legal system. So when we are talking, so our court system and our judicial branch is unique among modern democracies in that it has both judicial and policymaking powers. So what I mean by this is judicial power is just kind of the generic power that almost every judicial branch or judicial system in every country has, especially democracies, where the courts get to decide if people are guilty or not, right? That kind of thing. But in the US, because of judicial review and a few other things, our judicial branch has policy-making power. So the judicial branch can make policy, and because of that, it makes us unique. So our judicial branch is the cornerstone of our democracy because judges are meant to make impartial decisions about issues and the Constitution that often elected officials find difficult to make. And also, our courts are meant to be the watchdogs of our government and our democracy to make sure that everything works as it should. Now, our court system doesn't always do that, right? For a large chunk of the history of our judicial branch, right? The judicial branch said that it was perfectly fine to segregate by race, and that followed the Constitution. It very obviously does not, right? So keep that in mind that this is the ideal version and not necessarily what happens at all times. So the federal court system is kind of set up by three primary, or at least a bulk of it is set up by three primary sets of laws. The first is in the Constitution, and that's Article 3 of the Constitution. So that creates the Supreme Court. And remember, Congress in Article 1 is given the power to create all inferior courts below the Supreme Court. Well, it's also touched on in Article 3, but it is an enumerated power of Congress. But Article 3 only creates the Supreme Court. Right? No other courts are created by the Constitution. Now, state courts already existed in each of the states prior to this, but no federal courts. Article 3 of the Constitution creates the Supreme Court. One of the first laws passed once the Constitution was ratified and we have Congress and a president and all that is the Judiciary Act of 1789. So Congress establishes a Chief Justice position within the Supreme Court and creates 5 associate justice positions. So for much of the Supreme Court's history early on, there's only 6 Supreme Court justices. And at that point, they also add in lower level courts like the Circuit Courts of Appeal and District Courts. Okay. Now, if we fast forward time about 100 years to the Court of Appeals Act of 1891, this is going to change the jurisdiction and the role of Circuit Court of Appeals. So basically, it makes the second level of our federal court system an appellate level, which we'll talk about much more as we go on. And it gives Congress the authority to increase the number of federal courts as our population increased. Okay. But the main two are the first two, Article 3 and then the Judiciary Act of 1789. All right. So let's keep going. Now, federal judges, there's not really many formal requirements for federal judges. They serve for life and they serve as long as they're under good behavior. Now, there haven't been real interpretations of what that means. They're supposed to be independent. They're not supposed to be concerned about public opinion. They're not reelected, right? The point is to keep them separate from the will of the people, so that they can reflect the kind of the true nature of the Constitution. Now, again, remember the original Constitution included slavery, right? It doesn't explicitly say slavery because they didn't want to do that, but the ideas of slavery were baked into the Constitution. So keep that in mind. Like when we say that justices and judges are supposed to make sure that people's rights are protected by protecting the Constitution has not protected many people's rights for most of the history of the United States. But nonetheless, justices can be removed. Federal judges or Supreme Court justices can be removed if they're impeached for things like treason, bribery, or high crimes and misdemeanors. Basically, the same kind of threshold as a president is, or other officials. Now, you don't need to really write this slide down, but you should listen and keep in mind the jurisdiction pieces of this. So Article 3, again, it's one of the shortest articles in the entire Constitution. Creates the Supreme Court, gives Congress the power to create inferior courts, like we talked about, establishes life tenure for the justices as long as they're on good behavior, and says that they're basically their pay cannot be shrunk; it can't be decreased while they're in office. That's Section 1. Section 2 defines federal jurisdiction and defines the original jurisdiction of the Supreme Court, the appellate jurisdiction of the Supreme Court, and talks about trial by jury for criminal cases. Again, you don't need to write this slide down. So this is kind of what Article 3 is talking about for the most part. Now, let's talk about our final, the last of all of them, the final required Supreme Court case, Marbury v. Madison, which we have talked about endlessly, it seems like, this semester, but we've never actually gone into detail about. So we got to rewind time. We got to look right after the election of 1800. John Adams, a Federalist, was president, and the Senate was almost all Federalists. Thomas Jefferson and the Democratic Republicans absolutely destroy John Adams and the Federalists in the election of 1800. So not quite as much Jefferson. He wins by a small margin, but the Democratic Republicans win the Senate by a lot. So after that election, John Adams is a lame duck president, right, from November to March. At that time, you were inaugurated in March. We talked about lame duck last time. So he is just kind of there, right? And Thomas Jefferson, he knows Thomas Jefferson's going to be coming in. John Adams hates the Democratic Republicans and Thomas Jefferson. So he and the other Federalists, they create a whole bunch of new federal judge positions, which they could, and then they appoint a bunch of new federal judges. However, it took a long time because, it's the 1800s. And so by the end of his term, literally they were delivering these notices. So back then, the way that it had to work is you would nominate a judge, they would get approved by the Senate, and then they would have to deliver a paper to the justice who would have to sign it and then bring it back to the Secretary of State, and then they were officially the judge. So William Marbury was one of these Federalist judges that's appointed, and it takes too long to get him the paper. So he's been confirmed by the Senate, and all he has to do is sign this paper. But it took too long, and so Thomas Jefferson takes office, and James Madison becomes the Secretary of State. And it's his job to finalize this appointment and get Marbury to sign this paper. And so instead, he throws it in his desk and he says, nah, I don't want to do that because I don't want the Federalists to get their way. So William Marbury gets extremely upset because he had this nice, cushy, lifelong judge position set up for him that he now doesn't get. And so he sues James Madison, which is why it's Marbury v. Madison, and he asks the Supreme Court to order James Madison to finalize his Supreme Court position or his federal judge position. And so the constitutional issue here is, the big question is, does judicial review actually exist? And then there's three smaller questions that create that big question. So did Marbury have the right to a writ of mandamus? So a writ of mandamus is basically an order from a federal court to telling someone in the government to do something. That's kind of the idea here. So basically, Marbury is asking the Supreme Court to file a writ of mandamus against James Madison to order him to do something. And do the laws of the country give Marbury legal remedy? And then is asking the Supreme Court for a writ of mandamus the correct remedy? Now, let's talk about what happens. The Supreme Court rules 6-0 in favor of James Madison. And John Marshall, the Chief Justice of the Supreme Court at this time, he wrote that Marbury does have the right to a writ of mandamus because the Judiciary Act of 1789 gave the Supreme Court the power to order someone in another branch to follow the law or to do something. Okay, so the first two questions are a yes and a yes. But then John Marshall does something that's genius, and he says, but the Supreme Court can't give the writ of mandamus because the law that gave the Supreme Court that power violates the Constitution, because Congress can't pass a law that gives another branch of government more power, right? That's not within their powers of Article 1, right? It's not a power that they have. They can't give the Supreme Court more power like that. And so John Marshall, in saying that the Supreme Court doesn't have this power, creates the idea that the Supreme Court can review laws and decide if they're constitutional. Judicial review. Boom, we have it. We finally have the details of what happened in this case. I know you've been you've been sitting on the edge of your seats all semester waiting for this, and now you finally know what happens with Marbury v. Madison. By the way, fun fact, William Marbury never becomes a judge, and he's sad. Well, actually, I don't know if he's sad, but probably. And so the significance of this is that the Supreme Court now has the power of judicial review. Simple. All right, let's move on. Now, our last, also, again, hip hip hooray, our last required foundational document of this semester is Federalist 78. So Federalist 78 is another Hamilton Federalist paper, like many of the other ones we've read. And this one's all about the judicial branch. And basically it kind of gives the overview that the judicial branch, he says that, because remember, all of the Federalist Papers are an argument why the Constitution should be ratified. And so he says it should be ratified because the judicial branch it creates is too weak to do anything proactive. It can't take power, right? One of the things that anti-federalists were very worried about was that the judicial branch would become too powerful and be able to take power, and that they were serving for life. And so they could do whatever they wanted. They could become too powerful. And Hamilton says, no, that's not true. They're weak. They can't do anything proactive. They can't take power, right? And he says that it's okay the way that we're doing this because the states appoint judges in the same way that the federal government is going to. And he says that judicial review should exist, but he acknowledges it's not in the Constitution. But this is where you can kind of see that this was kind of the plan, the intention, but it was just not put in the Constitution. And he says that the judiciary, the judicial branch, is bound to the Constitution alone. It's not bound to politicians or to the other branches. It's bound to the Constitution. And in order to be bound to the Constitution, members of the judiciary have to be appointed for life, because if they're not, then they're subject to what he called political whims. Okay, so changing political ideals. So he also says in here that judicial power comes from the people, and because of this, the judicial branch is not superior to either of the other two branches, because the people are superior to all, and the Constitution belongs to the people. And so the judicial branch is carrying out the will of the people by striking down laws that conflict with the Constitution. So this is how he says that judicial review should exist, except he doesn't say it as judicial review. And again, it's not written in the Constitution, so that doesn't come till later. But John Marshall, when he makes his decision in Marbury v. Madison, actually cites Federalist 78 as some of the justification. Okay, so again, this is a required foundational document. If you look in the required foundational document review folder and slideshow, you'll see information there. And now you're done with all the foundational documents and required Supreme Court cases. Exciting stuff. You're so close. Now, the U.S. has what we call a common law system. So basically what a common law system means is that we have a set of laws that are that evolve over time based on decisions made by previous judges. And so judges are going to rely on what we call precedent. This is something we referred to a lot last unit. And basically this is deciding cases with references to former decisions, right? And usually we are following precedent, right? So for example, after Plessy v. Ferguson in the late 1800s declaring that segregation was okay, that separate but equal was a doctrine that worked, that fit with the Constitution, all the way until the 1950s with Brown v. Board of Education. The Supreme Court and other courts below it followed that precedent, that challenges to segregation, that as long as things were separate but equal, that fit with the Constitution. Right? So this is the idea of stare decisis, or let the decision stand in Latin. Right? So this is the idea that past decisions have weight and matter. Now, I will tell you, the current Supreme Court, kind of in the last few years, has made a habit of overturning far more precedent than most courts before it, in a much more rapid pace. So it seems that stare decisis may be mattering less than it has in the past. But we'll talk about that next week. Now, jurisdiction is another term that you are going to have to know. So jurisdiction is basically the authority to hear a case. You've probably heard the word jurisdiction before if you're watching like a TV show that has some like the FBI or cops in it, and they'll argue about jurisdiction, who gets to handle that case, right? So it's the same thing in the court system. So in the US, we have a dual court system. We have a federal court system and a state court system. So states have jurisdiction or the authority to hear cases over their own laws, right? So that's why in California, if you violated California state law, you are not prosecuted in the federal system, you're prosecuted in the state system. So federal jurisdiction generally has to do with cases that are in some way violating the U.S. Constitution, violating federal laws, or violating federal treaties, or they're what we call diversity cases. So this is when it involves a citizen in different states. So my little brother lives in Washington. If, let's say, we got into an argument over, I don't know, some business, let's say we opened a business together and we both own a share of it, and then I sue him, right? It can't be heard in a California court because that wouldn't be fair to him. It can't be heard in a Washington court because that wouldn't be fair to him. So it's heard in a federal court, so it's fair to both of us. A diversity case. Now, this is just an image showing you the dual court system. You don't have to write this down, but we've got state courts and federal courts that all have the Supreme Court at the top. So again, this is an image of the federal court system. You don't have to write this down, but it's in there for your information. Now, at the bottom of the federal court system, and I'm going to give you the term to help you remember some of this. So the lowest tier of federal courts are called the district courts, or they're basically trial courts. So these are courts that have what we call original jurisdiction. Make sure you have that down in your notes. Original jurisdiction. So we're going to abbreviate that as OJ, right? Original jurisdiction, right? Courts that have original jurisdiction have orange juice. They have OJ, okay? Or if you want to think of OJ Simpson, I guess that's okay too, but that's a little weird. So these courts have original jurisdiction, which means they're the starting point. So they are the ones where the court case starts. Okay. There are 94 district courts. There's at least one in each state. There's one in DC. There's one in Puerto Rico, and then there's many others that fit with certain subject areas of courts or cases rather than just in each individual state. And these courts have original jurisdiction over all federal crimes, civil suits under federal laws, and diversity suits, like citizens between different states. So they are the only federal court in the entire system where trials have juries. Every other court in the federal system is decided by judges, not by juries. So these courts look like what you've seen on TV or what you would see in like the Sonoma County Superior Court. Okay. So this is the district court or trial courts. And remember, they have original jurisdiction. They have OJ. They drink orange juice with breakfast. Okay. Then the second tier, the next tier up, is our appellate level court or our circuit courts of appeal. So there are 13 courts of appeal. So there's 12 judicial circuits, including a DC circuit court of appeals. So there's 12 of them. And then there's also the U.S. Court of Appeals for the Federal Circuit. That one's more about like patents, copyrights, international trade, things like that. It's subject matter. But the other 12 are based on where in the U.S. they are. Okay. So for example, over here in the United States or in California, we are part of the 9th Circuit Court of Appeals. It's in San Francisco. And so Circuit Court of Appeals, or the appellate level court, have what we call appellate jurisdiction. So they have AJ, apple juice. They like to drink apple juice with breakfast. Okay? So they are going to review, appellate jurisdiction means that they are going to review decisions made by lower level courts. So they don't, cases can't start in the appellate level. They start in the original jurisdiction level, the lowest courts, the district courts, and then they move to the appellate court if one of the groups does not like the decision and they appeal it to a higher tier. Now, those higher court doesn't have to hear it, but often they do. And so it's heard by a panel of 3 justices, and whoever's appealing, the burden of proof lies with them. And then it's a majority vote. So usually either 2-1 or 3-0. Okay. And remember, they have apple juice, appellate jurisdiction. So again, here's the 13 circuit courts of appeal. As you can see, in California, we have the 9th Circuit Court of Appeal, which also includes most of the Western states, including Alaska and Hawaii. Okay. This just shows you an image of the federal court system. So you've got the courts of appeals, you've got the district courts, and the Supreme Court. So let's talk about the Supreme Court. The Supreme Court, because these justices are the most important, they like to have both apple juice and orange juice with their breakfast. So they have both appellate jurisdiction and original jurisdiction. Okay, so cases can start in the Supreme Court or they can trickle up the system to the Supreme Court. Now, 9 justices currently sit on the court. This is an image of the 9 justices. There are 8 associate justices and 1 chief justice. That number is always set by Congress. It's ranged from 6 to 10, depending on the time period of U.S. history. And it's been 9 since the 1870s. So we're pretty locked in at 9. There has been some debate in recent years, especially after the Dobbs v. Jackson Women's Health decision. By predominantly Democrats, considering if they ever get a supermajority in the Senate, which, spoilers, no one ever will again probably in our lifetimes, they want to potentially, maybe, add more Supreme Court justices because there's a 6-3 conservative majority right now, which we will talk about. So the nomination process for a Supreme Court justice starts with the president. The president has the constitutional authority to appoint all federal judges, including Supreme Court justices. This is their check on the judicial branch. Then the Senate confirms all presidential appointments of federal justices. Okay, so they take a vote and they vote on these appointments. Okay. So there's hundreds of justices on federal benches throughout the federal court system. And so because of this, often the president doesn't necessarily know these people. And so they rely on other sources. You don't have to write the bottom part down, but they rely on the Department of Justice, the FBI, members of Congress, current justices, as well as interest groups like the American Bar Association. So spoilers, if you get to an FRQ ever that asks how an interest group could play a role in the nomination process, you could talk about them bringing potential nominees to the president, right? Now, if we keep going, right, the nomination process, because the Senate is that kind of more informal body and they have the idea of unanimous consent, among other things. Another idea that fits with that is what we call senatorial courtesy. So this is basically an unwritten rule that if the president is appointing someone to a federal judge position and the senior senator from the state that they're a judge in doesn't want them to be on the court, then the president will pull their nominee. This is kind of more an old-fashioned thing. It doesn't happen quite as much as it used to. But for a long time in U.S. history, this was super important. Now, when we're nominating the Supreme Court justice, presidents spend way more time vetting their nominees to the Supreme Court than they do any other court, because there's only 9 Supreme Court justices, where there's hundreds of federal judges at the other levels. And these are the 9 that, like, people know their names, right? I don't even know the names of any of the justices on the Ninth Circuit Court of Appeals, even though that's the one we live near. So presidents are going to see these Supreme Court nominees as part of their legacy as president. And in kind of the last 50 years or so, it's become a lot more politicized. For a long time, it was kind of tradition that like justices pretended like they weren't political. They didn't have political ideologies. Today, that's kind of an attempt, but it's painfully obviously that they all do. And there's nothing wrong with that, right? I think it's part of who we are as people to have a political ideology. So usually the ideology of the nominee depends on the party of the president and the makeup of the Senate. If the president's party is running the Senate, has the majority in the Senate, and they have a large majority in the Senate, usually you can get someone that is more ideologically on the outskirts, so more liberal or more conservative. However, if it's a slim majority and the president's party only has, let's say, 51 votes to 49 votes, usually they have to appoint somebody that's more moderate. Okay. So when the nomination process happens, the Senate Judiciary Committee interviews them, and it's usually like a week-long confirmation hearing where they will interview them, and then the Judiciary Committee will take a vote to send them to the floor of the Senate. And then if that passes, usually it'll pass the whole Senate. Not always, but usually. This gets more difficult if there's a divided government. Remember, where the president is one party and the House and the Senate, in this case the Senate, is a different party. Okay? So Generally, Supreme Court justices are selected based on these kind of 6 criteria. Now, it's not an official criteria, but this is usually what it's based on. It's based on ideology. So a Republican president doesn't want to appoint a super liberal justice, right? Dwight Eisenhower, one of the justices he appointed, he thought was a conservative justice. And by the time they retired, they were one of the more liberal justices in the history of the Supreme Court. And he hated that as he got older. He talked about it often. On top of that, generally, what will happen is presidents are appointing from their own political party. But remember, they will pretend like they're not members of political parties. It's this weird thing. They are. It's okay. 90% of the Supreme Court justices were members of the president's party before they became Supreme Court justices. Generally, the nominee has to be acceptable to the Senate, because if they're not going to get confirmed. And then the president has to start over. Generally, you want them to have some kind of judicial experience, although this is much more important at the lower courts than the Supreme Court. There is no official requirement to be a judge prior to being a Supreme Court justice. In fact, you don't have to even have a law degree. Okay? It is not required. Many presidents will take into account race and gender, right? So, for example, appointing as time went on, right? Trying to appoint the first woman, or the first African American, or the first Latinx Supreme Court justice, things like that, to try to increase the diversity of the Supreme Court, as the diversity of the United States has also increased. As you could probably assume, the vast majority of Supreme Court justices have been white men, just like the vast majority of all politicians in the U.S. over the history of the U.S. have been white men. So, that shouldn't surprise you. And then finally, usually there's a litmus test. This happens usually during a confirmation hearing, and it's kind of asking Supreme Court justices how they might decide on certain things. Prior to Dobbs overturning Roe v. Wade, a very common one was, do you think that Roe v. Wade is set precedent? And generally, liberal justices would say yes. Sometimes conservative justices would say no. It kind of depended. Now, let's look at our current Supreme Court justices, and this is where we're going to leave it. So we're going to go through these 9. So this first guy, this is the Chief Justice of the Supreme Court, John Roberts. He runs the Supreme Court. He's been the Chief Justice of the Supreme Court since 2005. He was appointed by George W. Bush, and he is currently 68 years old. If we're evaluating where he is on the political spectrum, we would call him conservative. So often we will refer to this version of the Supreme Court since 2005 as the Roberts Court. You generally refer to a Supreme Court makeup by the last name of the Chief Justice. Okay, so he was appointed by George W. Bush in 2005. Now, from now on, we're going to go in order from the longest serving to the newest. So Clarence Thomas was appointed in 1991 by George H.W. Bush, George W. Bush's father. He is 75. When he was appointed, he was very young. His appointment and confirmation hearing was very controversial. During the hearing, he was accused of sexual harassment, and it has come out since then. More women have accused him of sexual harassment. He was still confirmed by the U.S. Senate by a pretty wide majority of both Democrats and Republicans in 1991. He is currently 75. He and the next justice are definitely the most conservative Supreme Court justices. For example, Clarence Thomas does not believe that the right to privacy exists in the Constitution at all. Same thing with Alito, the next one. But some of the other conservatives believe that it exists, just not as explicitly as some others. Clarence Thomas was very famous for, in the first 25 years he was on the Supreme Court, he only talked twice. Once was to ask a question, and then once was to make a joke about the lawyer who was arguing in front of the Supreme Court because he went to a different college than him. Since then he has talked a lot more, but he had talked less than 5 times in his first 25 years on the bench. Next, longest serving is Samuel Alito, who was appointed by George W. Bush in 2006. He is currently 73, and he is also extremely conservative. He is the author of the Dobbs v. Jackson Women's Health decision that we've talked about a lot. And like I said, him and Thomas are the most conservative justices on the court right now. Then, if we keep going, Sonia Sotomayor was appointed in 2009 by Barack Obama. She is currently 69. She is by far the most liberal Supreme Court justice on the court. Interesting thing about her is she has become more liberal since she's gotten on the court. Generally, as people get older, they tend to be more conservative, but she has become more liberal in her decisions, which we'll talk about a little bit more next week. Then also another Obama appointee was Elena Kagan, who was appointed in 2010. She's 63. She's also a liberal justice, one of the three on the court, but she is much more moderate than Sonia Sotomayor. Then we get into the Trump appointees. So Neil Gorsuch was appointed in 2017. He is 56, one of the younger people on the Supreme Court, and he is kind of somewhere between moderate and Alito and Thomas. So he's not quite as conservative as them, but not quite as moderate as John Roberts, Amy Coney Barrett, and Brett Kavanaugh. Neil Gorsuch was his seat actually opened up during President Obama's last term, and President Obama tried to appoint Merrick Garland, who is the current Attorney General of the United States, for that seat, but the Republican held Senate refused to hear the confirmation until after the 2016 election, which then Donald Trump won. And so when they filled that seat, it was filled by a Republican, a conservative justice, Neil Gorsuch, instead. Then we have Brett Kavanaugh, who was appointed in 2018 by Donald Trump. He is 58. He is kind of a more moderate conservative, at least as far as the conservatives who are currently on the court. His confirmation hearing was definitely chaotic, and he was investigated during his confirmation hearing in a similar manner to Clarence Thomas, but still was confirmed. And then Amy Coney Barrett, who was the last appointee by Donald Trump in 2020. She is currently 51. She's the youngest Supreme Court justice on the court. Yes, she is the youngest by about 7 years. She is conservative, similar to Brett Kavanaugh. She has never been a judge before. Before she was a Supreme Court justice. And then Ketanji Brown Jackson was appointed by Joe Biden just last year. So she is the most recent appointee. She is 53, the second youngest Supreme Court justice. And she is liberal, a little more liberal than Elena Kagan, but definitely more moderate than Sonia Sotomayor. She is the first Black woman to serve on the court. So that's where we're going to leave it for today. We'll talk more about the makeup of the court next week. So please answer the question in the Ed Puzzle, and I'll see you on Monday or Tuesday.